be a significant crash. I don't know if there was some kind of crime, but something's going on just east of the old Reed and Reed
Yikes.
business. So yeah, because I mean it's literally stopped. And Millie, God bless her, she's been looking at all the cars out there for the last hour. So maybe we'll read about it in the paper or something. It's good to be back. I was on vacation
Yeah,
last
you were
week.
out last week.
Well, it
Ryan.
was the thank you Southwest Airlines for ruining my Christmas and pushing our vacation back. But better late than never. We had a good time. I know Ryan took over or filled in
Yeah.
for me. I don't
So you
know.
went skiing?
Yeah, in
Did you go
Breckenridge.
fast?
Huh?
Do you snowboard or
No,
ski?
no,
Yeah.
no. Just ski.
Do you
Yeah.
go fast down or do you like,
No, no,
slow,
no.
slow through? I'd
Well,
fall on my ass.
put it this way.
I've been like once.
Leanne got up to 56 miles an hour.
Yeah.
I'm
All right.
probably more in the, 35 to 40 range.
That's still fast.
I can't keep up with her.
I mean, that still
Or
hurt yourself fast. You've been to leg the wrong way, and
yeah.
man,
All
oh
right.
man.
So you when I was on vacation, you sent me a video, and of
Yeah,
course
yeah.
we all know that during the holiday season,
Hmm.
there are porch pirates that
Yeah,
steal things from
yeah,
your property, and also there are instances where people are on your property where they get injured. Whether and the question I think you'd sent was, well, you know, can trespassers on your property sue you for injuries they sustain?
yeah,
Okay,
yeah.
and of
This
course, there is a Florida statute that deals with this, obviously. And let's just start with the easy one. The
okay.
easy one
Do you want me
are
to show
these.
the video though? Because that one,
Uh, oh, do you have the one?
I have it. She
Yeah, let's
falls.
watch it.
She falls. Oh, okay, okay.
What the heck? Yeah,
Yeah,
roll
yeah,
tape.
good. Yeah, here we go. All right, so I fast forwarded up to where she's lumbers up to the porch, and
So this is somebody stealing a package from a porch.
yeah, you don't see it that good, but she's on the ground from this angle. I'll skip forward. She falls and busts her ass right there, though. She tries to get up and doesn't. And now let me
She broke
skip
her
ahead.
ankle.
Yeah, let me skip ahead to the scene where you
Well,
really.
karma's a bee.
Okay,
That's for
right here.
sure.
She tries to get back up, and her ankle just goes. Yeah.
You're such a weenie.
Bro. It
All
like goes.
right.
Her dude picks her up and carries her off, and her
That
ankle is
sucks.
just
No,
like
I hear you, a little flopper.
dangling,
Well,
bro.
here's
Flopper.
so all right. Well, cancel that. Let me ask
It's
you a
gone. It's
question.
gone.
This says Florida
Mm.
statute.
Okay.
A person or organization, meaning a company or building, controlling or owning an interest in real property, in this case would be the house, shall not be held liable for negligence that results in the death or injury to an individual who's attempting to commit a felony or who's engaged in a commission of a felony on the property.
Okay.
Stealing from a home, first off, stealing from the U.S. Postal Service
Yeah.
is a felony.
So taking it out of your mailbox is.
Well, no, the Postal Service delivers boxes to your door.
They can, but like with I guess a minute distinction between
Well,
an
it doesn't
Amazon
matter.
package
In Florida,
and okay.
basically, stealing a package from someone's porch could be considered burglary.
Okay.
A lot of issues. Bottom line is, more likely than not, and the value of it can make a difference. But basically, on that situation, this woman would not be able to sue the homeowner, in my opinion.
That gives me peace of mind.
Yeah. All right.
Jeez,
So there that one's an easy one. But
floppy dangling ankle. I'm sorry.
let me do this. Let me
I love
tell
watching
you
karma.
about a case we had.
Okay.
I don't know if I'm going to move this over so I can read it. So this was back in I believe the no not it was the started in the 90s, late 90s, early 2000. And what happened was a client of ours was driving down a roadway. It was Keysville.
This is the
And
pictures you sent me?
yeah, well, Welcome Road in Keysville.
You want me to pull that up?
Yeah, pull them up.
Okay, okay. Got it.
Yeah, Welcome Road in Keysville, and just show them.
Yes, there. It's up.
Okay. So what happened was our client, his name's Scott, had the family. They'd gone to someone's house. It was nighttime, and they were driving up Welcome Road, which ends, you see right there by the stop sign on Keysville. So it's a T intersection.
Yep, I see that.
Now, certainly when I pulled these pictures up, this could have been 20 years later, but do you see that fence in the background?
Yeah, the black one
The
or
fence,
the gate like
the
straight
gate,
across.
the
Yeah,
gate.
yeah, I see that. Yeah, yeah,
Okay, well, back in the day, all that brush wasn't there. There was a long, basically shell type road
yeah.
that
Okay.
went back onto the property.
Okay.
Okay, and about 100 feet in, there was still pavement.
Okay.
So you had 100 feet of pavement, and then after that, more or less like a limestone shell type of road, where ATVers and things of that nature would go back there and rip it up and so forth.
Okay.
All right. And so what the IMC back in the day did is they put this huge black pipe more or less where that gate is.
Okay.
All right.
So there wasn't a fence. There wasn't a gate.
Huge,
Just road pass through, no
about
gate,
100 feet.
no brush, and they put a big black pipe. Is that one of those big cement pipe things? Like the big cement
This was like a big metal black pipe.
Yeah,
Put
but
it
like
this way.
the big ones
It,
that you are
it wasn't go when he hit it at 55 miles an hour, it didn't move.
Yeah, so it's one of the big ones. Yeah.
So
Okay.
what happened? It's nighttime, and Welcome Road slopes up just a little. It slopes up such that the headlights kind of shined up into the trees.
Mm-hmm.
So Scott is coming up the road 50 miles an hour. Well, lo and behold, the county had mowed that area, and the stop sign was knocked over. So this is a perfect storm for him. He's doing 50 miles an hour. He's not familiar with the area. It's a T intersection. There's no stop sign. The headlights are shining up in the trees. Boom! He hits, and of course everybody's hurt. All right, so obviously we sued the county for knocking down the sign and not putting it back up. And we sued IMC for putting a black metal pipe on their property, which basically we consider was the proximate cause of the family's injuries.
Okay.
All right, so we're going doing depositions and things of that nature, and IMC takes the position that our clients were trespassers.
Okay.
Right? Now,
okay.
The law prior to 1999, I believe, was that the only duty you had to an undiscovered trespasser is, and I'll read it, is to refrain.
Undiscovered trespass.
Undiscovered, and he was undiscovered because he was on the property 2 seconds.
Right. Yeah. Right.
Was to refrain from intentional conduct, and then basically conduct that rises to the level of gross negligence. All right. Well, certainly there was no intentional conduct. They didn't swing a pipe at him, have a big. Okay, so that it wasn't. So then there was the issue was from IMC's point, we did not intentionally cause injuries to this family, and there was not gross negligence, which basically means, and I'll read it, gross negligence means that a defendant's conduct was so reckless or wanting in care that it constituted a disregard for the indifference to life, safety, and the rights of others. So that's gross negligence. It's pretty difficult to establish gross negligence. It's really, really difficult. But either way, of course, that's IMC took the position that he was a trespasser.
Yeah, that has to.
Putting the pipe there was not gross negligence, and did not intentionally cause the family harm. We argued that he was not a trespasser, that he was basically a type of invitee. It's kind of an unintended invitee, basically. And therefore the standard is you have to refrain from, let me see what I want to quote it.
Okay.
First you have the duty to warn.
Right.
to a,
Yeah, I was gonna say because of course they didn't sling a pipe at him, but if at that time he would have been more than an undisclosed trespasser, he
yeah,
would have been
so
aware of.
ours was, he was like an uninvited, I'm sorry, an implied invitee, and I can go through that, but under such
Okay.
circumstances, the property owners, he had to exercise due care to keep the property in a reasonably safe condition or warn.
Mm,
Kind of the standard slip and fall stuff. So you got
gotcha.
to maintain the property in reasonably safe condition or warn. Our position was, because there was no warning signs, there wasn't a T intersection. There was just nothing. It was just this big black pipe and with no lights, no warnings, no nothing.
Right.
Well, so that was it. So the circuit court says he has to decide as a trespasser, and if he was, then there's basically we would lose because there was no intentional conduct, and then the court would hold it wasn't gross negligence. Ours was implied invitee. They did not maintain the property in a reasonably safe condition, and they didn't warn.
Okay.
That was the gist.
Okay.
Well, circuit court, and it was Judge Arnold, God bless his soul. He's a mediator now that we use. He's retired. He kicked us to the curb. Yeah, he said, nope, he's a trespasser, and you guys, there wasn't intentional conduct, and it wasn't gross negligence. Summary judgment for the defendants, IMC, and out the door you go.
Yeah.
Yeah, well, that was a bummer.
Yeah, especially he had driven the road before.
Unfamiliar with the area.
Okay, so unfamiliar with the area, and it was dark,
Yep.
and the pipe was black.
Yep.
I don't know, man.
Well, it's not. Well, remember, the facts only matter based on whether or not he was a trespasser or an implied invitee.
Okay.
That's what the
So
case.
that's really the first pivotal piece that has to be decided before you can look
Correct.
at anything else. Okay.
Correct.
Okay.
So then, of course, because these people were, to say, injured, the residents during depositions, they thought like a bomb went off and came. This is rural. You can see the area. It's very rural, but people came running from miles
Oh,
away,
they heard
so to
that.
speak,
Yeah,
because it sounded. Dude, he hit it at 60 miles, 50, 60 miles an hour with
Did
no
they-
brakes.
Did he live?
Well, yeah. Well, it was not pretty. Needless to say, this case warranted,
Yikes.
because of the injuries, the medical bills, an appeal.
Yeah, I would agree. Yeah.
All right. So
Yeah.
here's the thing. I'm going to read it. The analysis. This is what the appellate judge. His opinion goes this. Okay.
So this is the appeal.
Says are there genuine issues of fact in the record that give rise to two different legal theories of IMC's liability? Let me go. It says there's the misleading private way theory. Misleading private way, and it says courts from numerous jurisdictions. Now, this judge went out of his way to write this opinion. Most of them are a paragraph. If you look at my book over here,
Yeah.
they're a paragraph.
So he went out of his way to
Well,
make
whatever
sure
he decided, he went out of his way to kind of clarify the law on this issue. It says courts from numerous jurisdictions have held that a traveler who enters private land that appears to be a continuation of the public highway becomes an implied invitee. Under such circumstances, the owner of the land may be held liable for injuries sustained by the traveler resulting from the property owner's failure to exercise due care to keep the property in a reasonably safe condition for travel. All right. And he talks about different jurisdictions. He goes to Maine. He goes to, these other states, which they usually don't. They usually don't care what other states do.
Okay.
And so
he's looking for a precedent.
Huh?
He's
looking for reasons to follow one way or the other.
Okay.
And and he goes on. It says on this one, the main court says if a person so surfaces and maintains his land abutting on a public highway as to indicate to the traveling public that such land is included in and is part of the highway. Now, mind you, remember I told you there's about 100 feet of paved road into IMC's property. Okay. He says with no such land is to public highway has to indicate that the traveling public that such land is included in and is part of such highway with no sufficient warnings to the contrary. He impliedly invites or allures travelers lawfully onto the highway to drive over the land as if it were part of such highway.
Okay.
So in such circumstances, the traveler would not be a trespasser on the land.
Okay.
So far as I'm reading this, I'm thinking this is good. I like this.
Yeah.
Very good.
See where this is going. This is nice.
Right.
Yeah.
Okay, so he does that. And then he says, and that's the implied invitee. And he goes on to talk about it, Prosser and all this other stuff in law school. So he goes, the next issue is the dangerous condition near or exiting a highway. And we've talked about this. I've talked about the sprinklers in your face.
Yes.
We talked about people putting those rocks to keep you from driving.
Yeah.
On the grass.
Leaves left.
Yeah. Well, right. It says, in addition to the misleading private way theory, the facts in this case pose a separate but related question concerning whether IMC's placement of the pipe at the end of the paved entrance to its property created a condition dangerous to persons in the vicinity traveling on Keysville or Welcome. It says, we may assume without deciding that Mr. Poe, as IMC contended, was an uninvited licensee or a trespasser on his property. It says, even under this assumption, so they're saying, even if my clients were trespassers, issues of fact precluded summary judgment. IMC knew that unauthorized persons used the abandoned entrance on Keysville to gain vehicular access to his properties. The ATVs were, riding, on the property. Thus, IMC's knowledge of the presence of such unauthorized persons on his property, it was undisputed. So there's an issue of fact concerning whether the placement of a large, non-reflective, rigid pipe at the end of the paved entrance to IMC's property created a hidden danger at night.
So he's ultimately saying that the summary judgment was presumptuous. That
was wrong. Let's use the word. Should not have been granted. There were material issues of fact. Now, mind you, we had hired a human factors expert to go to explain all of this, and his deposition testimony was in there. But yeah, bottom line at the end of the day says a possessor of land who creates or permits to remain thereon an excavation or other artificial condition so near or an existing highway that he realizes or should realize that it involves an unreasonable risk to others, accidentally brought into contact with such condition while traveling within reasonable care of the highway, can be liable for the physical harm.
Okay. So
what happened? Yes, that's right. We had
your day in court.
We got our day in court. Now, the beauty of this, Judge Arnold actually did us a favor by granting the summary judgment.
Okay. Yeah.
How, you might ask?
I would think that because this particular judge was so thorough in basically like lining up what the material things had to be, that when you went to actually have your day in court, those became the argument.
Well, that's one thing.
Point issues.
Well, here's what happened, Jason.
Okay.
So IMC is now out.
Okay.
Who's left? Who's left? Who's on the hook for all these damages?
The property owner?
Nope. Remember, the county, when they mowed the common areas, knocked down the stop sign and didn't put it back up.
Oh.
So now, even though the county back then had sovereign immunity and they only owed $100,000, they can't. Because the county was pointing the finger all along at IMC, saying, "Look, it's their black metal pipe. They're responsible. They created a known hazard, this, that, and the other." Well, once the Judge Arnold, ruled that IMC is not responsible, the county was the only one left.
Yeah.
County flips over its cash, right? Now they're out, and they had no intentions of settling at all. I mean, until Judge Arnold threw us a little softball, a little lob up there, And then this probably took a year, 18 months before the appellate court brought IMC back in. Now IMC's back in. We amended the complaint based on this case to list all of these things these judges told us should be alleged.
I gave you a roadmap.
Dude, it was not even a roadmap. It was a Siri telling you turn left here, turn right here.
Yeah.
And guess what? IMC settled.
Good.
So you got to say, Judge Arnold gave us lemons that turned into lemonade.
That's good. That's a great moral of the story, I think. Because I think there's a lot of times we hit roadblocks. I just feel like something is a dead end, and what do they say? Like when one door closes, another one opens, or a window somewhere opens, or something like that. I think that's very true. But also good on you for staying the course. Like that dude would have been screwed without you.
I couldn't agree more. I mean, I'm going to leave it at that. There are lawyers that would have done the same thing, and there are lawyers who would have said, okay, well, we're going to take the money from the county and we're not going to appeal, because it's a lot of money to appeal a case. Don't think it's not. It's a lot. But okay, so let's just go back. Wow. So now you're a homeowner. I'm a homeowner. So let's just kind of go back to see what the statute says. I just wanted to give that case. It was pretty interesting.
No, cool. It definitely raised a question for me, because my HOA stuck these white cross ties out in the grass right next to the road because they didn't like people edging onto the grass, and that has me all kinds of nervous. That's going to be an injury.
Wait, is it on your property?
It's next to my house or townhome, but but I don't own the property. That's the common area, so it's not my property.
I would still send them a letter. Say, please be advised that I believe that you may be liable if someone is injured, based on these things, and I want to be clear, it's your property and not mine.
Yeah.
Can't hurt it.
Okay.
But anyway, so here we go. So this is, Florida statutes. This is 2022, immunity from liability for injury to trespassers. Okay. This is number one right here.
Back to the Porch Pirates.
I'm just going to say a person. It's a person or organization, meaning a company or otherwise. But I don't want to read all that because we're going to roll on. So a person who has a controlling interest in real property, I'm going to skip, shall not be held liable for civil damages for death or injury to a trespasser on the property. And then it goes, when the trespasser is under the influence of an alcoholic beverage, with a blood alcohol of 0.08. That's legally intoxicated. Under the influence of basically drugs,
mind-altering substances.
Chemical substances. Or has like affected by something trespass affected by. All right. So basically, if you're drunk or high, and you get hurt. But here's the kicker. That's why you say there's no yes or no's in the law. However, the person or organization owning or controlling the property shall not be immune from liability if there's gross negligence or intentional misconduct. So again, the answer is The answer is yes, but no. If you go out, somebody's drunk, they're on your property, and you push them down the stairs, well, you're in trouble. You may be in trouble from a criminal standpoint, but from a civil, you're going to be liable. So if you do some kind of intentional misconduct. And here's what's funny. You know what made me think of this? What is that?
Because I've seen some of these porch pirate videos where the homeowner comes running out the front door, tries to grab it, the person falls off their bike or something as they're trying to get away. Those are different circumstances of what I'm.
Well, here's the deal. No jury in the world is going to convict you or make you pay for that. Hopefully. But let's just say you have a 2-story house. This was an actual Texas case. You have a 2-story house, right? And there's a trespasser on your property, and they are stealing. This is the case, stealing a battery out of your car.
Oh, okay. Yeah.
They're stealing a battery. They lived back in the day.
Yeah,
You
yeah.
could just pop the hood. You don't need the inside. And
Okay.
I don't know how old you
And
people
then you
are
go
out there
throw something
watching.
on top of them.
Guess what? The guy shot him.
Oh, okay.
Now the
Okay.
question was, um,
You're laughing.
can you be civilly liable for that?
I mean, that's Texas. So I don't know about Texas, but based off what you were saying, and if it was Florida,
Florida.
I would
In
say
Florida.
no, because he's conducting a
Well,
felony.
I don't know if stealing a battery would be
Oh,
considered a felony.
true.
Yeah.
Yeah.
And he's a discovered trespasser.
Yeah. Did he
That's
warn?
different. Discovered's
Did
different, you know.
stop?
Uh,
Drop. I don't. Yeah, I would say that if he didn't warn and if he didn't have a reason to think that he was also trying to steal the car or something, I guess that.
well, let's not change the facts. He's stealing a battery.
Yeah.
Well, in Texas, you can
Yeah.
kill somebody for criminal mischief. So in Texas,
Oh my word. Okay.
there was no civil liability.
So Texas is free and clear.
In
Okay.
Florida, you could be sued.
Okay.
Yeah,
Yeah,
because
that's something
you
people need to know.
basically you had intentional conduct
Mm-hmm.
uh,
Yep.
or a known trespasser.
And especially if you don't tell them. Yeah, I mean, like you just gotta let them walk off with your battery. Hey, drop that. You're not dropping it? No. Okay. Okay. Well, it's yours. Bring me some
Yeah,
cookies. I guess. I don't know.
yeah. So
Okay.
a discovered trespasser is again is a
Mm,
little different
yeah.
than an undiscovered trespasser.
And the felony part plays a big
Here's
deal.
the funny part, which you'll get a kick out of this. So
So if they're kicking over your lawn gnomes or
our
something,
case came out, and it was under the old statute.
okay.
So even our conduct happened under the old statute, right?
Right.
Well, I don't know if this case or not, but guess what the government did up in Tallahassee?
Tell me.
They changed the law. Oh yeah, they
Nice.
changed to this. A person or organization owning or controlling an interest in real property shall not be held liable for negligence that results in the death or injury or damage to persons who are attempting to commit a felony or who is engaged in the commission of a felony on the property. That's the
Okay.
change. That wasn't there before.
Okay. Yeah.
And then 3B, here's another thing. To avoid liability to undiscovered trespassers, a person or organization owning or controlling an interest in real property must refrain from intentional conduct that approximately causes the injury, but has no duty to warn. Meaning, if the jury had found that, I'm sorry, forget that on the felony. I was reading the wrong section. The felony was there. Okay, so forget that.
Okay.
Strike that, counselor. The felony was there.
Okay.
This one, they changed this to say that you don't have a duty to warn the trespasser, meaning if my clients the jury had found that they were trespassers, INC could have that pipe being there would not have cost them money.
Okay.
You follow me? I mean, I was a little convoluted. It says though that the trespasser, you still have to refrain from the intentional misconduct, but you don't have a duty to warn.
Okay.
Yeah. Which is the difference.
Interesting. Yeah. So especially with the felonies, like if somebody comes on and they're like kicking your lawn gnomes around or something like that, that doesn't count because it's not a felony.
Right. Well, and give you an example, what if IMC or anybody, there's a trespasser, right, undiscovered, and you put up something in your house, and or you dig a big hole.
Yeah, like a moat or a
whatever.
A slip and
fall. The trespasser comes on your property.
He'll break his leg on this.
Conduct. If they fall in the moat, they fall in your what'd you say, moat?
Your trap, your moat, yeah.
Yeah, and they die. They drown.
Mm-hmm.
You didn't have a duty to warn under the new statute.
Okay.
And
Okay.
it wasn't intentional conduct. You just have a moat around your house. So bottom line, though,
Yeah, it's interesting.
all that aside,
Okay.
you got to remember there's six in Hillsborough County. You're going to have to convince six people,
Mm-hmm.
all six, that this trespasser who's injured on your property is entitled to be paid by you.
Mm-hmm.
That's not easy.
No,
No,
it's not.
dude, I don't care what happened to him. You're
I
trespassing
think
on
everyone
someone's
empathizes
property.
with the
No, I'm not talking about a situation where, where like this. I think the fact that
like accidental.
IMC knew that
Mhm.
people were going on their property, to be honest, the ATVs were going on their property. I think all that they should have put up, one of those signs that go yellow or had the county, a yellow T at the end of it. You know what I mean? How you see them now when you come to a T, it
Yeah.
says left and right.
Yeah.
I mean, some easy things. A black metal pipe, no, And if you're going to, why don't you paint
Activated
it
strips on
white?
it. Yeah.
They have reflectors on
Reflective
it.
strips. Yeah.
Yeah, because the problem, what also was the fact that ATVs were just driving around
Going
it.
around it. Yeah.
So it really didn't serve its purpose. To the extent that it was
It's a
preventing
lot.
people from coming on their property.
That's a lot to process.
And so that's a little bit on the old trespasser property and otherwise. I
Yeah.
would say this though, those big railroad train tie logs that you put beside your property, and those rocks and those big boulders that you put on your property, right
Careful.
within a foot of the road to keep people from screwing up your grass, you're asking for it.
Yeah. Sounds like it to me.
Yeah. All right. Well, take us out. It's a beautiful
All right.
day.
Are you watching any of the football teams?
Of course.
I know the Bucks are out, so.
Oh, there's 4 teams left. There's
who are you?
Kansas City and Cincinnati play each other. That's Patrick Mahomes versus Joe Burrow.
Yeah.
You got Jalen Hurst for Philadelphia versus Purdy,
Eagles and
the
Niners.
quarterback for San Francisco. Now, mind you, Purdy, the quarterback from San Francisco, was the last pick in the NFL draft. God bless him. I'm rooting for him.
Yeah, that's an underdog story. That's cool.
Exactly.
Yeah. I like
Gasparilla's tomorrow for all of you people going. I've lived here 58 years.
It's a perfect time to talk about Pirates then.
Well, yeah, I've got 58 years. You know what? Don't get so drunk that you pass out on Bayshore. No, they're gonna. Jason, I don't know if you've had the pleasure, but they are passed out because they start drinking at 7 in the morning.
Yeah. I've heard stories. I don't go near that.
Jail is not fun.
I got 4 kids I got to take care of, man. I can't.
The hospital there at Tampa General is not fun. Waking up Sunday with a pounding headache is not fun. Maybe getting robbed because you're wearing some type of clothing or jewelry is not fun. Being injured, falling down drunk is not fun.
Everything's fun until you end up in one of those circumstances.
Exactly.
You just can't never predict when that's
have a good time. Moderate your alcohol and drug consumption because medical marijuana is now legal, and wake up tomorrow happy and safe in your own bed.
You're like the ultimate Tampa dad. I thought I was a dad with 4 kids.
All right, well, that's it. We've rambled on for 30, 40 minutes, and we're not going to ramble anymore.
All right. You got it. Have a great weekend, y'all.
You too.